productive day of discussions. We are really very privileged to have with us today Judge Margaret McKeown of the Court of Appeals for the Third Circuit. Ninth Circuit.
Congratulations.
So I was just testing to see if people were, kind of still awake after that post-lunch. We are incredibly lucky today to have Judge Margaret McKeown with us. Judge McKeown has been a real leader in efforts to try to promote representation in the immigration field. She has been passionate about this issue for quite some time. We've got her full bio here in your materials, and I encourage you all to read it carefully, because her career reflects such a range of commitments to social justice, to fairness, and to the very core of what a lawyer and a judge should be. She has been received many awards, which are highlighted in the materials, but several I'm just going to note because they really relate to what we're doing here today. She received the American Bar Association's 2010 Margaret Brent Women of the Year Achievement Award, the Federal Bar Association Community Service Award, and the Girl Scouts Cool Women Award, which I think is really one of the most impressive ones, and I can't wait to just see her cool woman comments for us today. Judge McKeown served as President-elect of the Federal Judges Association and President of the Association of Business Trial Lawyers of San Diego. She's chair of the ABA Rule of Law Initiative, Latin American and Caribbean Council, and past chair of the ABA's Committee on Federal Judicial Improvements. She's also on the advisory board, the Judicial Advisory Board of the American Society for International Law. She has many publications which are listed in our materials, but one of them is particularly relevant to today's discussion, and that is the piece that she wrote in a publication called Refugee Roulette, entitled The Counsel Conundrum: Effective Representation in Immigration Proceedings. During the course of the day today, many of the panelists in discussions relating to release procedures, relating to alternatives to detention, relating to conditions of detention, have referred over and over again to the importance of legal counsel. And Judge McKeown has really led efforts within the Ninth Circuit, and much more broadly, including, I'm sure, as well, in the Third Circuit and others, to shine a light on the huge gap in legal representation facing immigrants in immigration proceedings, and also at the circuit court level. And I'm sure we'll hear today about some of those efforts. One of them is the IJP ABA project in San Diego, which Judge McKeown really helped to inspire. So she has been making a difference in incredibly concrete ways on this very challenging issue of access to legal counsel in immigration proceedings. And so we're really privileged to have her here with us today. Judge McKeown.
Thank you. It's a pleasure to be here, and I was thrilled to see that Human Rights First was sponsoring this symposium, because it's timely and it's a topic that's not always discussed. So I'd like to start with a story. This is the story of Miss Asu. It's one of the earliest documented cases of sex trafficking in the United States. Now, Miss Asu was from China, and she was sold by her mother as a slave to a gentleman who was coming to the United States. So she was trafficked into the United States at Port Townsend, Washington, and she was only 16 years old and was what we now historically sometimes call a paper daughter. She was beaten, she was abused, she was forced into prostitution, and finally she escaped from Mr. Moisam, who was her tormentor, and she ended up at a home run by the Presbyterian Church in Portland, Oregon. So she stayed there fairly calmly for quite a while, but she actually was the only person in the Presbyterian Church Chinese Home for Women, uncharacteristically in Portland, Oregon, and so she was lonesome. So she finally told them she was leaving, and there was much to and fro. They didn't want her to leave. She left. She made her way to Seattle, and who should show up in Seattle, of course, but was her old tormentor, and he turned her into the immigration authorities. So it didn't take long, she was ordered deported. By then she had married someone, but it turned out that the bona fides of that marriage were in question. So she ended up in the Federal District Court in Seattle, Washington, where she found a somewhat sympathetic judge. That judge said, in effect, that he was appealing to the higher moral authority, because he said that the laws with respect to Miss Asu and the statutes, if he had to comply with those, they would be barbarous. He then said that if he were to send her back to China, it would be equivalent to remanding her to perpetual slavery and degradation. And he then invoked the 13th Amendment of the United States Constitution. That was 1905. He went on to say that it's actually shocking to contemplate that our laws would require a court to reach the conclusion that Miss Asu, through no fault of her own, ended up in this country as a sex slave, but he would need to send her back to China. So he vacated her deportation. And he said he can see no other way to emancipate this young woman from actual slavery than to vacate the deportation. The case then went to the Ninth Circuit Court of Appeals. Their briefing was brief, something we don't always see now, and the opinion was even briefer, something we don't always see now. So the court started out with the proverbial on the one hand, on the other hand. The court starts out as follows. This case enlists the sympathy of the court. That's always a good sign, but you always know there's probably a but. And here there was a big but. The big but was the Ninth Circuit said, we regret that the law does not permit us to yield to the humane considerations which activated the court below. I was captivated by this case, Miss Asu, and her history, so I found all of her immigration records in various places up and down the West Coast. And the last I found of her is March 8, 1906. She was put aboard the ship Manchuria, bound for Hong Kong. And beyond that, we know nothing more of Miss Asu. This case is more than 100 years old, but it's very rich with some contemporary lessons. The first of these is that, surprisingly, she was represented by two very able volunteer counsel, very well-regarded members of the bar. But secondly, of course, she lost her case. So even with these very able counsel, her very tragic circumstances did not permit her to prevail. And were we to fast forward and we were to take Miss Asu's case and we were to stick that into contemporary law, even with the evolution of sex trafficking laws, even with the evolution of the Torture Victims Protection Act and various T visas and other kind of relief, human rights treaties, she probably wouldn't fare much differently today than she did in 1905 and 1906. You know, Title 8 of the US Code, where we find all the immigration law, is very, very complicated. And my first visit to that section was somewhat unwittingly when I volunteered as a young lawyer to take an asylum case. And my asylum case, of course, had a very sympathetic plaintiff with not particularly great facts, but then I found he was married to a US citizen. Eureka! I thought that I had died and gone to heaven and that he might too be able to stay in the United States. But then I discovered that although he thought he had married a United States citizen, he was probably the only unwary immigrant to have married a Native American from Canada who had lived in the United States her entire life and thought she was a US citizen, but she was not a US citizen. So I then learned that these laws are a lot more complicated than they look, And nothing is easy in immigration law. And if I learned that as a young associate, I have reinforced that view, of course, having come on the Ninth Circuit Court of Appeals, where we have the largest immigration docket in the country. Which brings me then to the issue of counsel and what I call the counsel conundrum, as I noted it in my article for Refugee Roulette. It goes like this. There's good news and there's bad news. The good news is you have a lawyer. The bad news is you have a lawyer. So what does that mean? Well, one of the most striking conclusions that the various authors of the broader study in Refugee Roulette reached was, of course, that whether the asylum seeker is represented by counsel is the single most important factor affecting the outcome. That study was done in 2006. In the cases looked at, there were attorneys in about 1/3 of the cases, but relief was most likely to be granted if there was counsel, 3 times more likely if there was counsel than if there was not counsel. And one of my concerns is that those statistics actually obscure an even greater problem, and that is, what if you have a lawyer, but you have a bad lawyer? So sometimes no lawyer is better than a bad lawyer, and I'm sure one can disagree with that. So in my remarks, I'd like to address 2 points. One, I'd like to look at ineffective representation. That is, if you are fortunate enough to get a lawyer, let's hope that the petitioner can get a good lawyer. And secondly, the issue of lack of representation. And they are the most difficult to represent for a variety of reasons, not the least of which is often their physical location with respect to vis-a-vis where are the lawyers located. So if you're in San Diego, they are not located in downtown San Diego. You have to drive sometimes an hour, 2 hours to visit a client. The same is true in other places across the country. So not only are those cases legally more difficult, they are, as a practical matter, physically more difficult. So let's talk about when you have a lawyer, but it might be ineffective. I have read now literally thousands of appeals and petitions with respect to immigration. And I'd like to say I think I've seen it all until I see the next one. I've seen cookie cutter pleadings, pleadings where they didn't get the country right, where they didn't get the gender right, where they mismatched the name of the real petitioner with the petitioner from another case, where there was incomprehensible argument. And I save these, I usually pull them out, and every year when I lecture on trial or appellate advocacy, I use a few examples of things that when you read them are not comprehensible. It's not that they're bad English, it's that they're incomprehensible. Or maybe they failed to make the only claim that the immigrant had. I remember in one case, there was a mother from Mexico. She had 2 native-born U.S. citizen children. She'd been here since she was about 2 years old, and she had some documentary evidence as to hardship. Her lawyer either forgot, didn't have the time, experience to put in any evidence about her hardship. Her only possibility was to claim hardship. Well, as it turned out, when the state bar investigated that lawyer, he had something like 2,700 immigration cases that he had handled in a 2-year period. So maybe it was no surprise that he didn't have the time, experience, or wherewithal to put in documentary evidence. When we look through cases about lawyers, you find words like shoddy, irresponsible. One lawyer who said, I probably wasn't qualified to do this job. So one of my concerns, and something that we, I believe, institutionally in the courts, in the Attorney General's office, in the immigration court, can do something about, and that is ineffective counsel. Because certainly, if someone comes to our court and their counsel is ineffective, if they're detained, they certainly won't be in the courtroom. And often it's physically difficult for them to get to Pasadena, San Francisco, or Seattle, and they may not be in the courtroom. And even if they were in the courtroom, it's not necessarily always clear to non-lawyers, and I don't mean immigrants, I mean non-lawyers, whether or not you've got a good lawyer. A lot of times it just looks good. The lawyer stands up, the lawyer talks, the judge asks questions, looks good to me. But what if the lawyer forgets to make the statutory argument or doesn't understand the intricacies of the statutory system? So what's happening on that score? I give credit in California to the State Bar of California, which has stepped up its review of attorneys who have either been disbarred and are continuing to try to practice, notarios, and others who are practicing and giving bad legal advice. The State Bar is willing to pursue those claims and put the material together. They don't necessarily have the authority to prosecute, but they're turning them over to local prosecutors. And some of the local prosecutors are going forward. So the so-called proverbial bad apple is being weeded out of the system, but it's a slow process. But I do think the State Bar of California deserves enormous credit. Secondly, it's important for there to be court oversight. In our court, we have a watch list on attorneys who consistently miss deadlines, don't comply with the rules, are turning in briefs that are of substandard categories. Some of those are immigration lawyers, some of them are not. But we try to keep track of that so that we can work with the lawyers. Because our goal, of course, is for these lawyers to represent their clients well. The question you might say is, well, why would the court care? Well, we care as an institution. You remember that we are in the justice system. And justice doesn't mean necessarily that one side always wins or one side always loses. Justice means that you have a fair shot at making your case. And from our perspective, it's very important that every litigant who's there gets a fair shot. And if we see lawyers who are not doing well, and we see lawyers that need to be watched or spoken with or sanctioned, then it's our duty to do that as a court. But I want to underscore that our role and the role of State Bar and others is not just punitive. We have taken affirmatively a very active role in the Ninth Circuit to work on immigration counsel issues. First of all, we offer training programs that are free. These are probably the best CL deal, EL deal you could ever ask for. But basically, we create immigration hypotheticals. We bring lawyers to the court. They write a brief. It's critiqued by Ninth Circuit judges. They argue a mock appeal in front of Ninth Circuit judges. Now, amazingly, we get all kinds of volunteers also from big firms who want to come and participate in our free training, even if they're not immigration attorneys. But we're targeted to anyone who's doing immigration work, whether it's pro bono, paid counsel or whatever. We would like to make a contribution to the quality of the immigration bar. So our training programs, which we've run up and down the circuit, have been very popular and oversubscribed. We've also done other training programs where we work with the other agencies involved, whether it's with ICE, with the Department of Justice, and others. We've participated, of course, in the American Immigration Law Association programs. And finally, the judges on our court have done something that I don't think really had been done before, and that is we've actually sat down with the Department of Justice, with ICE, with immigration judges, to talk about the system and how all of this fits together, because we're all players in this justice system. And as you know, district court judges and circuit court judges meet frequently, not to talk about specific cases, but to talk about the justice system, to talk about how cases move through the system. And we said to ourselves, why aren't we talking with immigration judges? In the Ninth Circuit, there was a time when we had upwards of 7,000 to 8,000 cases a year in the immigration arena, and it was approaching 50% of our docket. That has fallen now. for a variety of reasons, but it still remains for us and for the Second Circuit an overriding portion of our docket. So with respect to ineffective counsel, I encourage you, when you think about counsel, not to think only about the uncounseled, but also those who are victims of bad counsel. And also that, I think, gives all of us a bad name in the justice system, lawyers. There's nothing worse than the public thinking that there's bad lawyers. That is not good for us, and it's not good for those who are represented. So let me turn then to lack of counsel. That's where you have no attorney. Well, again, having read hundreds, if not thousands, of these petitions, as judges, we sit around and we often kind of kvetch and complain. And at a program sponsored by Georgetown Law School, where they brought circuit judges together doing a lot of immigration, everybody was complaining. And what we were complaining about was a little bit less of the counsel on appeal, rather the counsel in the immigration proceedings at the trial level, at the IJ immigration judge level. Because what we see, of course, is just a transcript of that. And so we'll read page after page after page, and we'll see an unrepresented individual. And then we'll see even maybe they get counsel on appeal, and there's a major statute that was misinterpreted. These are statutes that for us are often very, very complicated. If you remember back to your mathematics class where you used to make those Venn diagrams and you would see what would overlap what, etc. When you take the immigration statutes, they're much like that, because you literally have to draw pictures and schematics of how they work. Well, if this, then that, if not that, then this, and what about this word, what does that mean? So we were complaining, gee, it's really at the lower levels we're seeing the problems. And as a result of that, that's how I got involved in the Immigration Justice Project in San Diego. I said to myself, if we're going to sit around and complain, we'll be here 5 years from now, 10 years from now, we'll have the same discussion. So why don't we do something about it? So under the auspices of the American Bar Association, we were able to start the Immigration Justice Project in San Diego. And one of the ideas there was to say, let's look at counsel not just as representation for the individual, but as representation for the system. Let's look at the system as a whole, because it's all part of the justice system. And I think one of the hazards of looking at counsel as just will the petitioner win is that it's too short-sighted. The question is the system better off? And when you talk with the immigration judges, when you talk with the Ninth Circuit judges, everyone will always tell you the system is better off with counseled clients. It works better, it flows better, there's less continuances, there are less issues, because individuals trying to work their way through this system without a lawyer, it is fraught with many difficulties. So, you know, whether it's time deadlines missed, whether it's the statutes, whether it's not understanding the procedures. So we combined at the Immigration Justice Project an academic study of what does counsel mean to the system, and that's ongoing now. Of course, as soon as that was up and running and there were actual clients, I stepped back and I, you know, I was the grandmother, but now I don't have any children because I can't participate, of course, and it's often, you'll hear, I think, from them today, very independent, working with the ABA. So at the immigration judge level, I think that's where the most critical point comes. The other thing that you have to remember from my perspective is that when Ninth Circuit sees a case, that person has lost at every level. If you only see cases where people lose, you get a pretty skewed view of the system. It's often true in the criminal law, too. We, on occasion, will see an appeal by a prosecutor, but in general, our criminal law appeals, we see someone who has lost at every step of the system. That's not true at the immigration judge, because that, if they have perhaps not been successful with the asylum officer, many people are successful at the immigration judge level, and that's why counsel is so important, because there are meritorious cases there. So I think direct representation programs, whether run through staff lawyers or through combination of staff lawyers and pro bono lawyers, are critical to the counsel issue. Second, I think that the Department of Justice legal orientation programs are fantastic because it's a way to work with a large number of individuals. And I think other court programs, for example, in the Ninth Circuit, if you take a pro bono appeal, we guarantee you an oral argument. Many, many of our cases, well over 80%, are submitted without oral argument. But as an institutional incentive, if you take a pro bono case from us on appeal, we guarantee that lawyer an oral argument. One of the questions comes up always is, well, we've had a recession, jobs are hard to find for law students, lawyers, and others. How in the world do you expect people to give pro bono time in the immigration arena? And I say appeal to their self-interest. I was a managing director of a very large national law firm. And one of the things we saw over time is that our young lawyers did not get enough trial experience. Now it's getting even harder because even if they're not getting it because of the firm, many courts, Los Angeles included, are closing courtrooms. There's much discussion in California about not only the shrinking, but the vanishing civil trial. So from a self-interest perspective, what could be better than the opportunity to put together a civil case, which is basically what an immigration trial case is, and take a case to trial as a young associate. So I think there's an appeal to be made there even in recessionary times. It's the old making, lemonade out of lemons. Before I close, I want to emphasize that just as on the Ninth Circuit, we often see those who have lost and we see a slice. When we talk about ineffective counsel or lack of counsel, we also are looking at a skewed picture. And I can tell you that some of the most able advocates that I've seen at the court have been immigration lawyers. So it needs to be said that there are many, many excellent immigration attorneys, and they're zealously representing their clients. They're doing a fabulous job. So in addition to undertaking what I think are institutional reforms, whether it's in the courts, either at the appellate level, the BIA, or the IJ, that's one thing I think we need to do, is really look, are there some institutional incentives to turn this counsel issue on its head? In the law firms, are there institutional incentives? But also, I think immigration groups and bar groups need to celebrate those great immigration lawyers that we do have. I think they are often not enough loved and sometimes overlooked, in the accolades that are given out by bar associations. So we should celebrate not just the pro bono lawyers, but I'd like to find ways to celebrate those immigration lawyers who day in and day out are in the trenches of cases which are often low-paying, very difficult, and very time-consuming. So in closing, I'd just like to say I applaud Human Rights First for convening this program and the many academics, government officials, and attorneys who work to support what I think should be a fair system for immigrants who are litigating their justice issues in our United States system. Thank you.